I refer to the General Comment 137 of the Committee on the Rights of Children that defines child sexual exploitation as an inducement or coercion of children to engage themselves in unlawful and psychologically harmful sexual activities, Your Lordship. And Your Lordship, it is upon that I evoke APDF and another versus the Republic of Mali, number 046 of 2016, where it was held that where a state maintains a legislation that does not protect children from harmful cultural practices, it maintains discriminatory practices which undermine the right of women and children and amount to a violation of its international commitments. And Your Lordship, it is upon that I pray to proceed and submit on the right to a human and degrading treatment. Your Lordship, the right to protection from inhuman and degrading treatment is guaranteed under Article 24 of the Constitution of the Federal Republic of Nsiki. And referring to the cultural practice that is in question here, how degrading is the cultural practice? Your Lordship, the cultural practice in question is degrading in a manner that children, imagine little girls, in primary and secondary are lured and coerced into sexual activities that it attains blessings unto them from their God Kampuri. Your Lordship, it is upon that I pray to proceed and submit on the right to equality. Your Lordship, the right to equality is provided for under Article 21.
I hope you are noting, because you'll be graded the same way. So far you've used 20 minutes and your colleague hasn't submitted.
Like, Your Lordship,
I thought you would divide 15 minutes, because you have 30 minutes. Is that so?
much obliged, Your Lordship.
15 minutes, 15 minutes, that's 30 minutes. So be mindful when you are submitting to not eat in your colleague's time. And also time management is part of the assessment. So you may have a lot, but you have to manage.
Much obliged, Your Lordship. I pray to be given 2 minutes to summarize my submission on issue 2. Your Lordship, it is upon that we submit and pray.
This Honorable Court rules in our favor and holds that the government failure to regulate the practice violated the said rights, and this custom must be regulated. I pray to submit.
Okay, thank you. Let's hear from counsel.
Much obliged, Your Lordship. My name is Alupo Lydia Innocent, and I'll use 14 minutes of this Honorable Court in advancement on my case to proceed on issue 3, 4, and make general prayers. Your Lordship, today...
Unfortunately, you have 9.
Much obliged, Your Lordship. Much obliged, Your Lordship. Your Lordship, today I'm in grief because human rights have been violated, Your Lordship. And these are matters that we should not underlook, Your Lordship. Your Lordship, in regards to issue 3, as to whether the failure of the state of Nsiki to provide essential training and information to girls, young women, vulnerable groups on sex and reproductive health, Your Lordship, is a violation of the human rights granted under Article 30, 32, 33, and 41, read together with Objective 14 of the National Objective and Directive Principles of the State Policy of Nsiki. Your Lordship, we as the applicants today submit that the government failed to provide information to girls, young women, vulnerable groups on sexual and reproductive health. Your Lordship, this omission violated Article 20, Clause 2, and violated the right to health, which includes sexual health and reproductive health. Your Lordship, the right to life guaranteed under Article 22. Your Lordship, the right to access of information guaranteed under Article 41. And Your Lordship, the right to education guaranteed under Article 30. Your Lordship, the government has a duty to promote and uphold the human rights, to uphold all human rights, and an omission of its duty led to a violation of various human rights guaranteed under Article 20, Clause 2. Your Lordship, at the back of our minds, and we are aware that the right to health is not expressively guaranteed in the Constitution of Nsiki. Your Lordship, but however, Article 8A Constitution of the Federal Republic of Insike, the government is bound to follow and respect national objective and the directive principles of the state policy of Insike. Your Lordship, Objective 20, the government is bound to provide basic healthcare services to its population. Your Lordship, an Objective 28, paragraph 1. Your Lordship, all states are to respect all international laws. Your Lordship, upon that, evoking Article 14 on the Convention on the Rights and Welfare of a Child, Your Lordship, guarantees that every child is supposed to get basic healthcare rights, basic healthcare services, Your Lordship, which includes sexual health and reproductive health. Your Lordship, the Committee on Economic, Social and Cultural Rights, Your Lordship, in General Comment number 14, defined a right to health as a fundamental human right, indispensable of the exercise of other rights. Your Lordship, every human being is entitled to the highest attainable standard of health, conducive to living a life in dignity. Your Lordship, what we mean by the highest attainable standard of health, this means that the health services are accessible and they are affordable to all its population, Your Lordship. Your Lordship, as I earlier on submitted, that the right to health includes reproductive health and sexual health. Your Lordship, reproductive health has been defined by the National Guidelines and Services Standards on Sexual and Reproductive Health Rights, 4th edition, at page 16, Your Lordship. Reproductive health is a state of complete physical, emotional, and social well-being of an individual in all matters related to the reproductive system, its functions and processes. Your Lordship, the importance and access of information about mature blood, the importance to have knowledge about reproductive health should not be underlooked, Your Lordship. Your Lordship, we see that many adolescents' needs have been largely ignored. Your Lordship, we see that in many countries, adolescents do not have access to information about reproductive health, Your Lordship. And yet, Your Lordship, these are matters that are critical and complex. Your Lordship, adolescents, both in and out of school, are to have knowledge about reproductive health, that they will be able to make proper decisions on their sexuality health, Your Lordship. They will be able to understand their reproductive system, on how their bodies shall grow, Your Lordship, and they shall not be lured into believing cultural myth, Your Lordship. Your Lordship, it's evident under paragraph 4 of our factors, the national education curriculum of Insike has not been updated since 1992, Your Lordship. And 85% of its students lag behind international standards, that they are not able to answer questions in day-to-day life. Your Lordship, even regarding their anatomy, they are not able to. Your Lordship, the home of the Brave Shelter, Your Lordship, the students got involved in unprotected sex, and even they were lured into believing cultural myth that if they swallowed contraceptive pills, the hair would grow around their nipples, Your Lordship. Your Lordship, these are just mere cultural myth, and they believe that they would attain blessings from their God Kaumpuli, Your Lordship. Your Lordship, proceeding to the right to life. The right to life is granted under Article 22 of the Constitution, Your Lordship. Your Lordship, in the case of Asero Patricia Ocheng versus Attorney General, 2012, Kampala Law Report. Your Lordship, the right to health is held to be interconnected to the right to life. Your Lordship, any violation of the right to health is a violation of the right to life. Your Lordship, having established the right to life, having established the right to health, I submit that there was a violation of the right to life, Your Lordship. Your Lordship, proceeding to the access of information and education guaranteed under Article 30 and 41 of the Constitution, and I will submit on them concurrently. Your Lordship, the economic, social, and cultural rights contains that access to information should be part of provision of reproductive health services. Your Lordship, Article 12, Clause 2 of the International Committee on Economic, Social, and Cultural Rights, Your Lordship. Your Lordship, the realization of women's rights, health, requires the removal of all barriers, interfering with the access of reproductive health. Your Lordship, what we mean by removing all barriers, we mean that we should sensitize these young girls and women about this mere cultural myth, Your Lordship.
Your Lordship, the right to educate, on the right to education, the Committee on Rights of a Child emphasizes that there is need for every child, both in and out of school, to have knowledge about reproductive health, Your Lordship. States should resolve a comprehensive sexuality programs in schools that will enable these children to learn about reproductive health. Your Lordship, as I earlier on submitted on paragraph 4, 6, and 9, and 10 of our facts, Your Lordship, it's evident the government of Insike failed to update its curriculum since 1992 and to pass a policy, Your Lordship, which was supposed to include sexuality education clauses, and these children will be able to attain sexuality education in schools. And even, Your Lordship, Sohad and Cohens, they had a plan to involve these activities, that they shall be able to, the programs through Know Yourself, Your Lordship. Your Lordship, the acts and omission of the government are highlighted in our submission as the right to life, the right to access of information, the right to education, and the right to life, Your Lordship. Your Lordship, the government of Insike should not be exonerated because it's the main protector of human rights, Your Lordship, and it should not deliberately or omit its duty. Your Lordship, I pray for a declaration that the inordinate failure and deal of the government of Insike to provide access to sexuality education, related information through age-appropriate sexuality education is a violation and threat to access of information and the right to education, Your Lordship. Your Lordship, I pray for an order that the government of Insike develops an enabling policy for the access of sexuality education through age-appropriate education within a stipulated period. Your Lordship, in regards to issue 2, I pray for a declaration that the failure of the state to pass a policy on sexual and reproductive health and protect vulnerable groups from harmful cultural myth, Your Lordship, and practices with a violation and a threat to Articles 8A, 22, 24, 33, and 44 of the Constitution of Insike. Your Lordship, I pray for an order that much obliged, Your Lordship. I request for 2 minutes of this Honorable Court.
1 minute.
To summarize. Much obliged, Your Lordship. Your Lordship, with these declarations and orders, the government should understand that the omission and duties attracts consequences, Your Lordship, and it's held liable, Your Lordship. And will help us boost its attention towards protection, promotion of human rights for the good of the people. Your Lordship, we so pray.
Okay, thank you, Council. Mr. Kabire, wait for you. Did I pronounce your name well? How do you pronounce your name?
Much obliged, Your Lordship. Mukabire Moses.
Mukabire Moses. These customs that you are complaining about, is customary law part of the laws applicable in the state you've dragged to court? Is customary law applicable?
Much obliged, Your Lordship. Yes, indeed, customary law is applicable in the state of Insike.
Which customs are allowed by the court or are recognized by the court?
Much obliged, Your Lordship. The customs that are allowed by the court are such customs that do not contravene Article 2, Clause 2 of the Constitution of Insike, and Objective 24 of the National Objective and Active Principles of State Policy. And Your Lordship, evoking the case of law advocacy for women versus Attorney General, it was held that all citizens have a right to culture that is granted by Article 37 of the Constitution of the Federal Republic of Insike. But although, Your Lordship, such cultures must not be in contravention of Article 2, Clause 2 of the Constitution of Insike.
Ms. Alupo,
Much obliged, Your Lordship.
in 1 minute, can you explain the violation that you seek to challenge before this court?
Much obliged, Your Lordship. Your Lordship, the right to health. We see that the Committee on Economic, Social and Cultural Rights, Your Lordship, in General Comment number 14, it defined a right to health as a fundamental human right, indispensable of the exercise of other rights. Your Lordship, every human being.
I want you to bring out the violation from the facts.
Yes.
The violation.
Yes.
Not the law. The violation complained of.
Yes. Much obliged, Your Lordship. Your Lordship, paragraph 14 and 9. 9 students of the Brave Home Shelter made an improper decision to involve themselves in unprotected sex, Your Lordship. This was a violation of the right to health, which includes access to information about reproductive health. Your Lordship, if these students had knowledge about reproductive health and how to handle their sexuality, Your Lordship, I don't think that they would have accepted to acknowledge into mere cultural myth, Your Lordship. This is because that their access to information was limited. And Your Lordship, the access of information moves hand in hand with the right to health, Your Lordship.
Okay. Thank you.
Much obliged, my Lord. For purpose of court record, my name is Sanda Sharif, the Attorney General, appearing on behalf of the respondent, with my co-counsel, Nasje Gloria, the Deputy Attorney General. My Lord, I'll first respond to the submissions made by the applicant. First and foremost, we agree that this court has jurisdiction to hear this matter, and that would not disagree. With the permission of this court, my Lord, you'll allow me proceed to respond to the applicant's submissions made under issue 1 and issue 2. Much obliged, my Lord. Under issue 1, the applicant submitted that the Republic of Insiche failed to provide access to information through appropriate sexuality education. It's the respondent's submission that the Republic of Insiche has not failed to provide access to information through age-appropriate sexuality education. In responding to that issue, my Lord, I'll make one head argument, and I'll rely on Article 2 of the International Covenant on Civil and Political Rights. My Lord, this is what it states. That it requires states to take the necessary steps, adopt such laws or other measures as may be necessary to recognize the rights enshrined thereon. The Republic of Insiche has observed Article 2 of the ICCPR, whereby it has justified the right of access to information under Article 41, Clause 1 of the Constitution. My Lord, the Republic of Insiche has even taken a further step of being a member of very many international human rights instruments which recognize the right of access to information. My Lord, among those human rights international instruments is the African Charter on Human and People's Rights, which recognizes the right of access to information under Article 9. Furthermore, my Lord, the Convention on the Elimination of Discrimination Against Women under Article 10, under Article 10H, also recognizes the right of access to information. And also, lastly, my Lord, under the ICCPR, Article 19, Clause 3 also recognizes the right of access to information. It's the respondent's submission that the state has not failed to provide access to information, basing on Article 2 of the International Covenant on Civil and Political Rights, which requires states to take appropriate measures, and among those measures is the adoption of such laws, which laws, my Lord, we have adopted, as seen in paragraph 4 of the brief acts. The applicant alleges that the government has frustrated the right of access to information, whereby it frustrated the Know Yourself campaign, which was a collaboration between Sohadi and Kohanes. My Lord, the government did not frustrate this program. It was only a guidance by the Ministry of Education that such endeavors, such collaborations were only supposed to be between the ministry and the private parties, not private parties among themselves. This was a guidance. It would be different, my Lord, if the ministry came up and said, we do not want you to take any measures, or we do not want you to give any information to these adolescents or to these children. The ministry only advised. It gave guidelines, which actually the applicants failed to follow. And that is the reason as to why, the reason as why the respondent submits that we did not frustrate the programs of SOHAD and Kohanes. The applicant further submitted that we have failed to update the curriculum and we have also failed to provide learning materials. My Lord, if you could turn with me to paragraph 11 of the brief facts, whereby the respondent stated that in a report to the Congress that we are unable to implement the recommendations made by SOHAD. The inability was shown under the financial constraints that the Republic of Insiche was going through. My Lord, under paragraph 4 of the brief facts, it's well stated that the state was facing a COVID-19 pandemic with the rest of the world. And this explains why it is financially unable to provide or to implement the respondents' recommendations. We have not refused that these recommendations are bad. And neither is the respondent submitting that there is no need for age-appropriate sexuality education. We actually uphold that right because we have so far ratified a number of human rights instruments, both locally and domestically. We have also incorporated these articles. And furthermore, my Lord, the right of access to information can actually be enforced by the courts. This is justified because the right of access to information is provided for under Article 41, Clause 1 of the Constitution. All those efforts, my Lord, show that the state or the Republic of Insiche, my Lord, is much willing, only that has been unable to actually put in place the recommendations given by SOHAD. It would be a different story, my Lord, if we were before this court and the applicants were submitting that actually did not find any importance of these recommendations. Actually, we uphold those importances. However, the right of access to information through age-appropriate sexuality education, whereas we're enforcing this right, my Lord, we cannot forget the welfare principle of these children. Which welfare principle, my Lord, is stated under Article 4 of the African Charter on the Rights and Welfare of the Children, which states that the best interest of the child shall be the primary consideration of every state. And furthermore, my Lord, General Comment 14 of 2013 by the Committee on the Rights of Children stressed that when determining the best interest of the child, the characteristics of the child shall be considered. What are the characteristics of the children at this stage in the Republic of Insiche, my Lord? These are adolescents. When they think they are sexually mature and they can't have children, but they are not yet ready. The curiosity at this stage, my Lord, is very much higher. It means even if we're upholding the right of access to information, this should be done in the best interest of the child, so that actually we do not let their best interests to be let down. My Lord, it is also the respondent's submission that actually we are having the willingness of providing the right of access to information as we have already elaborated to you. Proceeding with my submissions, even when the applicant did not provide a clear definition of what sexuality education is, my Lord, allow me to do so. My Lord, in the case of the Center of SEHAD versus Attorney General and Family Life Network, which was the High Court Civil Division Miscellaneous Cause number 309 of 2016, it was stated by Justice Lydia Mugambe that sexuality education includes information on the use, abuse of drugs, among them is alcohol, tobacco, and other substances, safe and respectful social and sexual behaviors. My Lord, if this is the content that is in sexuality education, we need to provide this content in the best interest of the children. We cannot let anyone at any time using anything to provide this access to information, even when the state were having the willingness to do so. My Lord, I would like to persuade this court with the guidelines on combating sexual violence at page 22, whereby it was stated that sufficient funding, training to combat sexual violence must be given to different professionals. This information that is supposed to be given to different professionals, among the professionals are parents, the police, all security agents, intelligence, judges, magistrates, and courts. This shows that the right of access to information needs to be upheld with the utmost care because all these stakeholders must get to know. And that is why, as the respondents, we submit that we actually have not failed to provide access to information. We're just doing this in a step-by-step manner for the best interest of the child. We therefore beg to submit on that issue that we have actually not failed to do so. My Lord, proceeding with my submissions in regards to issue 2, whereby the applicant submitted that the state has failed to pass a policy in regard to sexuality education. The applicant cited a blanket of articles that he alleges have been violated by the state, which articles have not been given a clear elaboration. My Lord, I would like to bring that to your attention. However, he cited Article 21 of the Constitution, whereby everyone has a right to equality. My Lord, you will allow me read verbatively for purposes of removing any doubts, where Article 21, Clause 1 of the Constitution says that all persons are equal before and under the law. And in every other aspect, including equal protection of the law. Subsection 2, Clause 2, my Lord, again makes it clear that without prejudice to Article 1, a person shall not be discriminated against grounds of sex, race, ethnic, tribe, birth, creed, or religion. We cannot make a policy that discriminates people basing on their tribes. We cannot policy a policy which discriminates people basing on their ethnic origin. And that is why the state has not failed to pass a policy in regard to sexuality education. However, it is making sure that the policy is inclusive because, one, people have a right of culture provided for under Article 37 of the Constitution. And all these people need equal protection. We cannot protect one party and forego the other. My Lord, it is the applicant's submission that we have not failed to pass a policy on sexuality education, but rather we are making sure that actually everyone is inclusive. In the case of Sehad versus Attorney General High Court,
Counsel.
Yes, my Lord.
Because when you interpret Article 21 that way, don't you think you are contradicting yourself with the submissions you made earlier regarding welfare?
I beg your pardon, my Lord?
When you interpret Article 21 in that context, that you cannot make a policy that discriminates against individuals who would wish to practice culture, and that would mean that you don't want to pass a policy that discriminates against people who would wish to participate in their culture. Doesn't that contradict the welfare principle that you submitted on? So how will you balance the two? Because on one hand you're saying you don't want to pass a policy that discriminates, that takes away the right to associate, you know, that is cultural practices. And yet in your earlier submissions you stated that you're very interested in the welfare of these children. How do you reconcile?
Much obliged, my Lord. Indeed, in the equal protection of all people, even children inclusive. But when we're protecting the children, we must ensure the best interest of the children. And that is how the two are related. There's no contradiction, my Lord. That under equal protection, even the children inclusive, but in the protection of the children, their best interest or the welfare principle must be upheld.
Which cultures are allowed, are recognized at law?
Much obliged, my Lord. Under Article 2, Clause 2 of the Constitution, it says that those cultures that are not inconsistent with the law, and customs that are not inconsistent with the law.
Is that so?
In regards to the case at hand, we agree with the applicants that these myths are inconsistent. However, when addressing these myths, we must also respect the right to culture and ensure equal protection of all the parties without discrimination basing on the tribes.
Okay, proceed.
Much obliged, my Lord. I was still submitting on the second issue as that the state has not failed to pass a policy on sexual reproductive health rights, but rather it cannot be held liable owing the principle of progressive realization. My Lord, the concept of progressive realization states that states must implement reasonable and measurable plans, including set achievable benchmarks. This was also upheld in the case of Sehad versus Attorney General and the Executive Director of Mulago High Court Civil Suit number 212 of 2013. This means that whereas we're implementing the policy, we must still we must still uphold the principle of progressive realization. Article 2, Clause 1 of the International Covenant on Civil and Cultural Rights obliges the states to take measures to the maximum of its available resources with the view of achieving progressively the full realization of these rights. And that is why we're actually passing this policy progressively. And even then, my lord, it's not that the state has failed to pass this policy. This policy is foregoing the exact process. It is still before the Congress. It is still being discussed. And we're waiting for the views of the congressmen and congresswomen as already stated in the brief facts at paragraph 11. Therefore, it would be an abuse of separation of powers if this court finds that, if this court intervenes in the affairs of the legislature or the Congress, which is still discussing the bill, which mandate is given to the legislature or the Congress under Article 79, Clause 2 of the Constitution, which requires the legislature to make the laws. And therefore, the legislature is doing its role and making this policy.
Is there a difference between policy and law?
Thank you very much, my lord. A law, the difference is minimal, because
who makes the policies?
Government policies can be made by under subsidiary legislations, by ministries, yes, and the laws are made by the parliament.
Okay, proceed.
Much obliged, my lord. So the policy is still under process, as already submitted, as already seen in the facts at paragraph 11, and we're waiting for the decision of the congressmen and congresswomen. And therefore, if this court proceeds to intervene in the legislative process, it would have been an abuse of the principle of balance of power, which restrains the court in not trespassing onto the part of the legislature, which has been reserved by the Constitution, and this was stated in the case of Force versus Ministry of Safety and Security, 1987 South African case at paragraph 19. It is therefore the respondent's submission that this court finds that we have not failed to provide access to information regarding Article 2 of the International Covenant on Civil and Political Rights, and we have also not failed to pass a policy on sexuality education. It is just we are just in respect of the progressive realization principle. With that, we beg to submit that this court upholds the fact that we have not failed to do any of the two in the first and second issues. I beg to submit.
Thank you, counsel. Let's hear from co-counsel.
May it please this honorable court. My name is Nasija Gloria, as earlier introduced by my co-counsel. Issue 3 is dealing with whether the failure of the state to provide and ensure essential training and information to the girls, young women, vulnerable groups, and institutions was a violation of their rights guaranteed under the Constitution and applicable law. And it is in response to the submissions made by the that and the right to health are progressively realized, and they are subject, and the principle of progressive realization is provided for under Article 2, Clause 1 of the International Covenant on Economic, Social, and Cultural Rights, and it provides that states are to take all the necessary steps using the maximum resources in order to realize economic, social, and cultural rights. My lord, furthermore,